What's his name?
David Floyd.
Court calls the case People versus David Floyd. Next time, make sure to check before we go to another block with me.
Assistant prosecuting attorney William Rose on behalf of the people.
Motion of Mr. Assistant Public Defender, heard on behalf of Mr. David Floyd. Mr. Floyd, please state your name for the record, please.
David Floyd. All right. This is People's motion.
Yes, Your Honor. At arraignment on Tuesday, the defendant was given a PR bond. The defendant was arraigned on 4 felony counts. The first being unlawful imprisonment. The second, third, and fourth were 3 counts of strangulation, all against the same victim. They occurred over an extended and prolonged period of time at multiple different locations with at least one independent witness who called and reported the incident. Another witness who did make a statement to the police was the victim's 16-year-old daughter. And in fact, during the last strangulation, which occurred in the home, the only reason that the defendant stopped was because the 16-year-old daughter yelled at him to stop strangling her mother. We had requested, I'm trying to find my motion now, Your Honor, but we had requested $200,000 at the cash or surety for a bond amount at the arraignment. And over our objections and bond argument, the magistrate gave a PR. Beyond the particular facts of this case, we are concerned about the defendant's criminal history, which includes a 2001 conviction for armed robbery, a 2007 conviction for felony firearm, a 2011 conviction for firearm possession by a felon, which was enhanced with a felony habitual third offense notice, as well as he did have 2 felony domestic violence cases in 2023. Both of them ended up being dismissed in December of 2023, and they were with the same victim. I do want to put on the record that we are concerned because it appears that during arraignment, part of the reasoning for the PR bond was that the victim did not appear and that was why those 2 felony domestic violence cases were dismissed in December. And according to my arraignment attorney, the statement by Magistrate Fink was that there's nothing in the record to indicate that that was at the hand of the defendant. Additionally, we are concerned because prior to arraignment, the defendant made at least 1 jail call to an unknown number where he provided the victim's phone number to that unknown male. And he indicated to that unknown male that his mom needed to call the victim, talking about some belongings. He made a statement, I did some hoe shit. All in all, the seriousness of the offense charged, the fact that it was in multiple locations over a prolonged period, there were independent witnesses, and not just independent witnesses, but a minor child who had to intervene in order to get the defendant to stop, as well as his criminal history, gives us serious concerns for his danger to the community as well as to the victim is if he is out.
Thank you, Judge.
Mr. Priester.
Obviously, I was not the attorney at the arraignment yesterday, but hearing what I've heard today and reading the notes in the file, I have several things I guess I want to touch on, Judge. First of all, being that nothing has changed today that wasn't said yesterday at the arraignment. Magistrate Fink heard all of these arguments and in her infinite wisdom made the decision to give the client a PR bond. Now we're asking for the defendant to have a $200,000 bond. So if anything has changed, nothing has changed in the nature of $200,000 to where his bond should go from a personal bond to a $200,000 bond. Additionally, my client's last convictions, if I heard correctly, were in 2011. So there's been 13 years since he's had any conviction that I have heard of at this point, Judge. Additionally, I don't know whether or not the complaining witness appeared at the arraignment, or if she didn't appear at the arraignment, whether or not Magistrate Fink weighed that as determining client's bond. But what I do know is that the complaining witness apparently did not come to some dates in 2023. She is not here today. We don't know if she'll be here at preliminary examination. So I'm sure Magistrate Fink did consider all those things when setting the bond. And the other thing that the people argue in their motion, and I believe it's number 12, is that my client made a phone call to a male and told that male to call the complaining witness. I would disagree with all of those statements in that number 12. If you look at the police report, the phone number listed for the complaining witness is not the phone number that the client gave to the male. That phone number is listed as a secondary number for the complaining witness and another primary number for the 16-year-old daughter, his stepdaughter, who he does not have a no contact order with. So I do not think that that is stated appropriately, that my client tried to reach the witness party. I think that is, if you go get the phone right now, it is not in the complaining witness's possession. The complaining witness never has that phone with that phone number. That's the number ending in 9827. That number will be in the hands of Kayla, the 16-year-old stepdaughter. And so that is not my client trying to make contact with the complaining witness in any way. So I disagree with that statement completely, Judge. So in summary, what I'm saying is that there have been no changes from yesterday. There are no calls to the victim. There are no attempted calls to the victim. There is no reason why the bond should go from a PR bond to a $200,000 bond. I'd ask the court to maintain the bond where it is. Mr. Floyd lives in Detroit. The complaining witness lives here in Glencoe. If the court wants to give Mr. Floyd a tether, which he was given yesterday by Magistrate Fink, was a high spot not to go to Glencoe Hills, that's fine. If the court wants to give him a tether with him not to come to Washtenaw County, that is fine. He has no reason to be here. He has no reason to have any contact with the victim, the complaining witness in this matter. He does have 2 minor children that he has parenting time of every weekend. He lives in Detroit. He works in Detroit. He's starting a new job in Detroit on March 18th, in Pontiac on March 18th at Amazon. And so I don't think there's anything that's new here, that's been said here, that should change the defendant's bond from a personal to a $200,000 bond, Judge.
Me, as I understand, at least the facts that have been relayed to me, at some point, some of these activities are occurring in the proximity of the children. There were 5 children that are there at the apartment, right? And again, it's just my impression by this that the 16-year-old is yelling stop, but these children are still in that vicinity.
That is correct, Your Honor. The victim's 5 children were sleeping in the residence, including the 16-year-old minor child when this occurred in the residence.
Okay.
That's my understanding, Judge. There were 5 children in the residence. All of them asleep, except for the 16-year-old.
Okay.
Who is the oldest.
Okay. And so part of what concerns me is I don't understand. Let's just take the 16-year-old, leave the others aside. With the 16-year-old, I don't know why I don't have no contact with her.
Fair.
Right? So that's one thing. I guess I should preface all of this by indicating, counsel, I reviewed the video of the arraignment, which I do customarily with these motions so that I can be clear as to what's there, because everybody's thinking certain things are said, not said, whatever. So I have an issue with that. I also was trying to clarify the 2 children. Are those 2 of the 5 or are those other children?
Other children.
Okay, so with the 5 children, is there any reason this defendant would need to have contact with them?
So he's married to the complaining witness in this case. Those 5 children are her children. He considers them to be his stepchildren, but he does not have to have contact with them until this matter is resolved.
All right, that's one thing. The other thing in terms of the monetary amount of the bond, again, as I'm to at least understanding the facts, there are numerous events occurring at various places. Part of the difficulty that I'm having is that at arraignment, public hearing the allegations, or at least seeing part of the allegations, at least as described by, well, wherever they may have gotten their information, maybe they would have gotten the police report or part of the police report, I don't know. But even the public defender appearing for the purposes of arraignment did not request a PR. And so that gave me great pause. I'm not saying that it's got to be the number that the people want, but I think even able counsel is in looking at it and being with candor to the court, given the circumstances, it wasn't asking for a PR bond. And then a PR bond gets set. So I have issues with the fact that the children weren't included in the no contact. I also have issues with nobody was requesting a PR and a PR gets set. Certainly the magistrate within their discretion could do that. But my firm belief is that and in looking at this, and I mean, I always hate saying it, but it sounds to me like it's an abuse of discretion in terms of the bond that is set. And so for purposes of rectifying all of that, I'm going to make that finding. And I'm going to reset the defendant's bond in this case. And again, Mr. Feaster, I think it, in terms of making this argument, you've seen at least the police report.
Yes, have judge, yes.
All right. Anything else? I am going to set a monetary bond in this matter. Anything else?
No, judge.
Given the circumstances and looking at it, I will order, I need the names from, you can provide those so that minors' names don't go out, but you can provide those to my court staff and we will include them in this order. I will set the defendant's bond at the amount of $50,000 cash surety in this case. The tether provision, should he post, would continue in this matter. All right. Well, let me do this. Is there a reason, if you posted, is there a reason for you to be in Washtenaw County at all? All right. So we'll need an order. I'll amend the GPS provision so that, sir, you can't enter Washtenaw County. Okay. So I would amend that provision. I just, if you're out and then if you're driving around, just be where people mess up. And I try to let people know this so that they don't do it. It's just the highways, because sometimes you cross over and then it would go off. Okay. So I will sign an order to that effect so that if he gets out,
Thank you.
Can't be there, can't have contact with any of the, which you're referring to as the stepchildren. all of the other conditions that the magistrate put in place would also remain in place that aren't inconsistent with what I've ordered.
Okay. Thank you very much.
All right, thank you.
Call me. I can reach out to get your keys and the rest of it.
Yes,
Oh,
I don't need a signature. How's the case of the people versus Julie Bontebal?
Mr. Assistant Public Defender appearing on behalf of Ms. Vampachan. Ms. Vampachan, please state your name for the record.
Julie Vampachan.
Thank you, Judge. I believe we are here. I think the court set this matter for a bond review prior to her preliminary examination that is apparently in about a week and a half.
Yes.
Okay. Your Honor, I was not here at the last one, but my understanding is that the issue raised at that time was surrounding phone calls to the complaining witness in the MDOP case.
Well, so that you're up to date, the original remand was because of missed drug testing and really lying to the court about things. We're going to get to the next hearing, and I set it a week out in hopes that maybe there could be some understanding, but then she goes into custody and then begins to violate another court order by not just a few calls like the last hearing we just had, but 41 calls in that week's, which I didn't even understand that.
Yes, Judge. And so my colleague who had the case at that time has had a lot of chance to review all of those 41 phone calls, and he had a chance to meet with Ms. Vampachan and discuss the nature of that with Ms. Vampachan. My understanding is the complaining witness on that case is also present here in the courtroom today. And so there's a lot of things, I guess, to address, Judge. The first one being that I think she was allowed to have contact with the complaining witness if it were about the minor children, but by text message, not by phone call. Obviously, these calls, she's not denying she made them. She's not denying that they had conversations. My understanding from my colleague who listened to the phone calls is that the bulk of them conversation was about the minor children. And I spoke to the complainant witness in the hallway. He indicates there's a correction I need to make on the record. There was some confusion about who actually had custody or possession of the minor children, and that her sister might have had the minor children. He says that he has the minor children. He says that her sister only has the minor children when he goes to work. So for the bulk of the day and night, he has the minor children. And so he says that their conversations centered around those minor children. And so I guess I need to make that clear for the record as well, because I
41 of them.
I mean, like I said, the bulk of them were about the minor children. Some of it was just conversation that ranged outside of the children that she should not have done, Judge. But she sat in jail for the last 2 weeks. She'll tell you, if you give her a chance later on, she'll tell you what she learned during this time period. Since last week, you revoked her phone privileges. She has had no phone calls clearly through her account because you revoked her privileges, and there are no phone calls through any other account. She did not try to go around the court's order. She heard what the court said. She has had no contact with the complaining witness. She understands where she messed up, and she's hoping the court will reconsider her bond situation, Your Honor. And the complaining witness in the MDOP case is here, and he is asking, I believe he's reached out to the victim advocate, and he is asking the court to drop the no contact order on the MDOP file. The other file is a ARNO with police officers, and so she will have no contact with them regardless, Your Honor. But she is asking you to please consider reinstating her personal bond. As the court already knows, she has 2 minor children. She was the primary person who watched those children while her significant other worked and supported the family. She also had her own job where she worked as a stock keeper for the University of Michigan. She's been in that role for over 15 years. If the court might remember, she missed about 3 weeks of work due to being hospitalized with pneumonia. Now she's missed another 2 weeks of work due to her lying to the court. And so she's trying to get back to work, keep that job that she's had for over 15 years. She's trying to get back to her children, trying to get back to her family. And I think she can tell you honestly, she sees where lying gets her. And it's not going to happen if the court gives her an opportunity. And I think she understands when the court issues an order, it's not a suggestion. And she will follow your orders from here on out, or she'll spend the next however long in jail. And she never wants to be back in jail. This has not been a good experience for her, Judge. But she admits to the violations of both the phone and
What did you want to tell me, young lady?
I wanted to say that I'm sorry for violating bond conditions and lying. And the 41 phone calls were about my kids, finances, things that I didn't get to take care of before being in jail. Work, daily life, and jail conditions. I never threatened or intimidated or told anything for me. I never talked about the case. And I'm a mother. I miss my kids, even if I didn't talk to them on every call. Even just hearing their voices in the background made me get through my day. I made a mistake and I'm sorry. And if I do get out, or when I get out, I'll store community corrections phone number in my phone. When I wake up every day for my kids to go to school, I'll make sure I call first thing in the morning. I'll quit smoking weed. And I'm sorry. And I've been at my job for 15 years. I missed a lot of work. I'm about fired. I can possibly get my job back. But if I'm in here any longer, I'm gonna lose everything. My 401k, my health benefits. I need to get back to my kids. I miss them, they miss me. They don't even know I'm in jail. I told them I was on vacation because I don't want them to know.
Why'd you do this? I don't.
Sorry.
But why? I mean, when you came here the first time, not the very first time, but when we got the bond violation report, why didn't you just be straight up about it?
I was scared to tell you that I was smoking. I was stressed out, like, due to this case. I've never been in trouble. I've never been in jail.
You know, what was really problematic about it is you started to lie and you were really talking to your attorney, but I don't think you even realized what you were saying didn't make any sense. And it didn't make any sense with what was in the violation report. I mean, that's how I could tell that you were lying. And then even on that, you just kept it going. And I don't know where you thought you were going to end up in the end. If you thought you were going to be successful in it, you weren't.
I understand. Now I know, and I learned. Sitting here thinking for 2 weeks, I learned.
For what?
For lying.
tell them what you've been doing in jail.
I've attended church. I've been cleaning inmate cells when they're leaving. I started a women's group, and I've just been trying to keep busy.
And you know, then when you came back that next week, last week, because of the way that the contact provision reads, one of the things I said to myself was, had there been 2-3 calls a day, frankly, ma'am, I would have excused that. And the reason I would have excused that is because You were permitted to text regarding your kids. But you can't do that from the jail. So I would have said, okay, I get it. She's just trying to keep that connect. And I probably would have just let that slide. But you can imagine that all of a sudden, when the prosecutor tells there's 41 calls. How old are your kids?
5 and 6.
Obviously, in some way, ma'am, you could keep yourself together, haven't been in trouble, haven't done anything. I don't know why you decided to do this. I hope more than anything that the one thing that you figured out is, first of all, trying to lie to the court is not the way to go. I can deal, people come here every day. I can deal with people that do sort of messed up things and don't make the right call if they're straight up with me. The worst thing is, and I'm sure, and I would hope that this is what you're teaching your kids, you don't lie, and then when they're caught, they just double down on the lie. That never gets anybody anywhere. Do you still have your job?
I don't know. They told me that I wasn't allowed to miss any more days after I came back from being sick.
As to the violations that she admits to, is there anything, Mr. Peach, you want to say before I sentence her on the violations?
It's been a long day, Judge. Just to briefly reiterate, she's got her kids, she's had her job, she's sorry, she's a proud woman, and she didn't want to admit she was scared, and she lied at the one place you can't lie. She understands that now, and I think it will never happen again, Judge.
I hope you still have your job. Defendant having admitted to the violations, I'll sentence the defendant to 14 days, Washington County Jail credit, 14 served. Her previous bond is reinstated at $10,000 personal recognizance bond. All of the conditions that were originally set remain in place. You understand that, ma'am?
Yes.
You need to get back on your testing. Just everybody has stress, right? Just find another way to deal with it. Make your test, just do your test and sort of walk yourself through this case and get it done.
Yes.
All right.
Corrections. Yeah. Get out if get out today, they probably be closed. But if not, tomorrow morning, 9 a.m. Thank you very much, Judge.
Thank you.
From a legal standpoint, this hearing focused on whether the defendant's original personal recognizance, PR, bond adequately protected the victim and the public. Prosecutors argued that the seriousness of the allegations, including multiple felony charges, repeated strangulation incidents, the presence of a minor witness, and the defendant's prior criminal history, created a substantial safety risk that justified increasing the bond. The defense countered that no new evidence had emerged since the arraignment, emphasizing the defendant's employment, family responsibilities, and the existing GPS restrictions. After reviewing the case, the judge concluded that the original PR bond was an abuse of discretion, noting that the alleged violence occurred around children and that the no-contact provisions did not sufficiently protect all potential witnesses. Rather than granting the prosecution's requested $200,000 bond, the judge struck a middle ground by setting a $50,000 cash surety bond, maintaining GPS monitoring, expanding the no-contact order to include the children, and prohibiting the defendant from entering the county. The ruling illustrates how courts balance the presumption of innocence with the need to protect victims, witnesses, and the community while ensuring that bond conditions are proportionate to the circumstances of the case.